Yes.
And I'm an Vishiman. I'm allowed to make a prayer.
Yes, yes.
I hope your Lordship is not going to weekly list today, being Saturday, or your Lordship will take.
No weekly list today.
No weekly list. That's fine. That is what I wanted to know. But one
Yes.
request to my lords: there are
Yes.
3 matters in weekly list. Okay, my lord. All these matters automatically will go to some other.
Yes, yes. Monday. Yes. Yes.
My lord,
Your
item
Lordship.
number one may kindly be urgent to next week because I am
1 minute.
sick.
1 minute. 1 minute. Yes. Mentioning item 1, I'll take it up. Yes. Mr. Mahapatra, you wanted to say something?
Yes, Lordship. Lordship, in item 14, on behalf of Senior Advocate Manas Mahapatra, I am praying for a 1-week adjournment, Your Lordship.
14.
Yes, Your Lordship. Criminal Revision 770 of 2018, Your Lordship. Kalika Prasad Das.
2018.
Yes, Your Lordship.
Is there any interim order?
Yes, Your Lordship, but it's in the second sub-item, Your Lordship. There is another matter attached with this. I think it's 703 of 2018. My senior advocate, DP Dhara, is appearing in the second sub-item.
Yes, item 14.
My lord.
In the first item,
Yes.
he is asking for adjournment. Mr. Mahapatra is not available.
Staff is also conducting this case, I guess, personal difficulty.
Other than, everybody has a problem today. Okay, adjournment. I'll adjust it, give a date. Interim order to continue. Huh? I'll adjust it, give a date.
My lord.
Second item, there is first item.
It's all right. That covers both of them. Yes.
Obliged, Your Lordship.
Yes, sir. Yes, sir. Are you saying anything?
No.
No.
I'm on item number 2.
2.
Item 1.
1, somebody is asking for adjournment.
Item number one, my lord, suffering from fever may kindly be taken on next week.
What is this item? Why it is listed this special?
Defect removal to defect removal.
Have you cured the defects? Pointed
Yes,
out
my
with
lord.
this.
Yes, my lord. Yes,
Cure the
my lord.
defect.
Yes, my lord.
Why do you want adjournment?
Suffering from fever as well as my senior is also suffering from fever. I am from Bhubaneswar, my lord. I am not in a position to go to the court.
February. No interim order is there.
Okay. Yes,
Item
my lord.
4.
Lordship, item number 2, 3, and 4 are all related, arise out of the same procedure.
Yes. 2, 3, and 4.
2,
Okay.
3, and 4.
Yes.
The gist of the case is that in item number 2, the petitioner is the accused in a case of disproportionate assets. The case is under investigation and charge sheet has not yet been submitted. In the meantime, during house search, the accounts of the petitioners, all the petitioners were recovered, the passbooks, and thereafter the investigating agency issued letters to the bank that the accounts be freezed. And accordingly, the present petitioners had moved before the learned trial court for releasing the accounts.
Yes.
And the learned, during the pendency of the application, Lordship, the Vigilance Department submitted that it has got no objection to the defreezing of the accounts. And they further submitted that they have also instructed the bank accordingly to defreeze the accounts. And the learned lower court held that there is no occasion of passing any order because the other party has admitted to it. However, the learned lower court ordered that the accounts kept in the accounts be kept as such, and the petitioners will be permitted to operate the account. That is the order passed, which is now impugned in this application. My grievance is that, Lordship, the reasoning regarding the freezing of the accounts, the division bench of this honorable court as well as the honorable apex court have held, both the decisions are there. I have filed on the last occasion also. I had submitted, Lordship.
Then it is only academic.
Lordship, the point that has been urged by the learned apex court is that there is a specific provision in the act itself for attaching the property. So the honorable apex court says that without resorting to the provision, you cannot check the
But
property.
in any case, you got back your account.
Lordship,
Account has already been defreezed.
Lordship, I got back the account. My grievance is that, Lordship, the past account, there are many accounts, only 3 I had sought. My grievance is that the account of the petitioner in the first application, that is item number 2, is his salary account. Then my grievance is that the account that is freezed of the petitioner number 3, petitioner in the second application, item number 3, is a loan account from which EMI are to be paid. And my grievance for the item number 4, the petitioner who is the son of the principal accused, he is not an accused in the case, and he is a medical officer working, he is a doctor, and the account is his salary account.
But
There is a-
everything is now defreezed. by the order of the-
Yes, Lordship, my learned friend on the last occasion submitted that he does not have any objection if indemnity bond is submitted for releasing it. ଆପଣ ଯାହା କହିଥିଲେ।
Hmm.
18A refers to attachment and confiscation. We are not on attachment and confiscation.
Hmm.
Into ଗୋଟେ account ଯୋଉଟା କହୁଛନ୍ତି keeping balance as on date of search,
Hmm.
they may operate the account. So
No,
what
no,
will happen?
they-
25 ଲକ୍ଷ 2 ଲକ୍ଷ 4 ଲକ୍ଷ ସବୁ deposit ଅଛି ତାଙ୍କ account ରେ. If there is a DA case, if they will taken it away, and what will happen to the fate of the case?
Of the case, if there is a bond, he will submit. But my grievance is, Lordship, may kindly listen to me.
No, then
my humble
your
submit.
release of the account,
Release of the amounts.
defreeze of the account is conditional. You are agreed by the conditions.
No, not the account is a decrease.
Then
Account is a decrease.
retaining the amount.
The retaining the amount. My submission is that, Lordship, since section 5 subsection 6 provides for attachment, and attachment is the mode by which you can keep the property. As such, the property cannot be disposed of. And my submission, the Honorable Apex Court who has held that without resorting to the provision, you cannot keep the property. And accordingly, my humble submission is that because they have not resorted to the provision, therefore, I say, Lordship, that the order of the learned lower court directing that the amounts be kept as such is not sustainable in law. That is my humble submission, Lordship. And in case Lordship holds that the amount should be kept, then also because of the peculiar facts of the circumstances, as I am aggrieved with the order, one is a loan account and the other 2 are the salary accounts, of which the salary has only flown. And accordingly, I urge Lordship that in that eventuality also, if Lordship holds, then I can also submit indemnity bond that will protect the amount also.
Yes.
Bank guarantee कौन? Indemnity bond देने में bond देने आओ, bond तो दे। Account है या
No. As on 15/12/2022, whatever balance is there, they have to maintain. That was the order. That was the order. He says that those because it is salary account and the other account.
आगे पूरा salary तो मतलब legal income ना,
There are
loan
4
account.
1 minute. Let us find out way. 2, 3, and 4. And there are 1, 2, 3.
2 is the accused.
4 matters. Okay.
3 matters.
All are related.
The same case.
All are from one family or
2, 3 is the wife, 4 is the son.
okay. Then you can think of giving.
우리 투구 뭐야? 로 세세고 되고 보기.
ଅଛି account number ଅଭିମନ୍ୟୁ ଚୌଧୁରୀ, one account number last digit 3586 ରେ 2,21,000 some odd, there is balance. Then account number
केते केते बेस
5389 wife 36,14,000 some odd. Again in say son account out account रे लक्षे
So the total how much? Total how much? What is the amount withheld by you?
withheld है ना, तो wife का account रे अच्छे 36 लक्ष 14,000.
এটা লোন অ্যাকাউন্ট আছে 30 লক্ষ লোন আসছে
Okay, 36 next.
ପୁଅ ଆଉ ୱାଇଫ ର ଛାଡି ହବନି ଆଉ ଗୋଟେ ଆକାଉଣ୍ଟ ଅଛି
Nay, what?
12491 another account 12491 stands in the name of the Susmita Sahu. That can be different your lordship may consider it.
I am four,
Nah.
the petitioner in the application, the serial number 4 is not an accused. Is not an accused and is a government employee and it is his salary account.
Susmita Sahu.
So, no, the fourth. Abhimanyu. Abhimanyu is the first petitioner. Amir Prasad Chaudhary. Serial.
On the ground that
Are you ready to give property security, consolidated property security for all? One property
Property
security
to
for all.
ସବୁ ମୋର siege କରିଛନ୍ତି a property ଆଉ ମୋର କୋଉଠି property ଅଛି indemnity bond ଦେବି I can give a bond I can execute the court ଆଜ୍ଞା
You seek
ଆଜ୍ଞା ଆଜ୍ଞା ଆଉ କଣ instruction ନେବେ ର
in the loan account, where from you got 36 lakhs?
90 lakh is the loan amount
You disbursed
ଆଜ୍ଞା
second loan.
ଆଜ୍ଞା
Show me that.
ଦେଖିଲୁ
Show me that.
ଆଜ୍ଞା ଦେଖିଲୁ
Show me that.
FIR ଟା ଦେଖିଲୁ
No, from the petition you showed me. Which one?
ଆଜ୍ଞା ଆଜ୍ଞା lordship
Susmita Sahu you're talking
ଆଜ୍ଞା
about.
ଆଜ୍ଞା
Okay, let us.
ଆଜ୍ଞା
Is bank dispersal from the
देखो,
loan
देखो,
sanctioned loan account, then
देखो
you have to release it. Let us.
that will be tested.
देखो lordship
If 90 lakhs is the sanction
आज्ञा देखो
loan, and out of that 36 is disbursed to you, and that can be released. I'll just pass it over. Just
आज्ञा
go through and tell me.
आज्ञा
I pass over. Okay.
आज्ञा
Wait, we can dispose it up. What is this?
lordship
We can dispose it up.
lordship
Yes.
item number 8 9 25 lakh 20
I don't know, sir. Where are you?
and there is
Where are you reading?
FIR lordship
Is it part of record?
no not the part of record is lordship
So therefore,
I will file the FIR
you
House
file and
loan
tell
is
me-
85
tell
lakh.
me if you are saying that this is a loan account
lordship
and 90 lakhs was the sanctioned loan.
85 lakh sorry,
85 lakhs is sanctioned loan,
85 lakh
and it is 36 lakhs which has been seized is disbursed by the bank towards the loan account, that has to be released.
lordship
You demonstrate that and straight away pass the order.
lordship
You can't withhold that. You can't.
Then I have to take instruction move on
You give it, I'll take it up Monday, Tuesday.
lordship Monday
If it is a loan account from out of the sanctioned loan, if something is disbursed lying in the account, you can't take it up.
I got
ठीक है lordship Monday I will file
No, you have to give 1 day.
Lordship.
1-2 days.
Monday
Let it be then, let it come on 6. 6. All the 3 matters.
हाँ
You give the detail of the accounts and source.
नहीं एप्रिल करी की देवी आ गया
Yes. Please do that. Okay. Yes.
Item 5.
May it please your lordship. My lord, in this case, your lordship, I have also verified item 5. Oh, sorry, 4. ଅଲଗା matter କି 4ଟା ସେ 2 3 4 କହିଲେ ହଁ କହିଲେ ହଁ ହଁ ସରି
Yes. Here.
Item 4, your lordship.
What do you want?
Lordship, confirm your lordship case diary.
Yes.
But though I have wrote letter to the mentioned police station and responding police, not yet received your lordship next week.
Okay.
In the meantime, I am looking for the case diary in this matter.
Yes, that was କିଛି ଦରକାର ନାହିଁ. My friend wants I cooperate with him. I have no.
There is last order there to obtain case diary. your
As
lordship.
per the order dated
I have already wrote letter to
6/11/2024, the Land Council for the state has not yet received the instruction, hence he seeks one more adjournment. These the matter on charge.
Fourth gulo ki?
After a week or so, we'll see. I'll give you a date. Is there any interim order?
No.
You move application if I'll give a longer date, you move application before
No,
trial.
I want to close the matter. Yes, as early as possible.
Okay.
Item 5.
Yes.
Item 5, your lordship,
Yes.
that I verified that to my assessment, your lordship, the petitioners no way connected to the crime. Till then, your lordship, may kindly see page 47.
47.
My lord, I may be given the liberty to move every point in the charge. This is the judgment. The day police paper supplied on the same
You are
day.
against the cognizance order.
Order, so also charge order I have annexed. I have read for entire Quashing. Your lordship may kindly see our own Hon'Ble High Court interpreted, taking into consideration the new law that even if it is not applicable, the spirit of law is that accused must be given a fair opportunity in charge. So every point I'll raise, your lordship may kindly see page 47. This day police paper was supplied. This squarely covers my case. I may be given an opportunity to file a discharge petition. Let the points be raised there and let magistrate take a decision.
I'll just record that and dispose it.
This is the judgment I am submitting for my.
You submit it. Who stops you?
No, I have given a copy to him also.
But what happened that order, your lordship kindly glance page 47, order of charge is framed on the 15/11/2023.
Yes, my lord, yes,
This
yes.
is 5 and 6 or only 5?
That is
Item 5.
Item 5, your lordship.
item
Item
5.
5. Okay. Petition is agreed by the order. Why? There are two orders you are impugning.
15, I have challenged cognizance also charge order. Page 47 is the charge order. 15,
Charge has already been framed.
framed.
Then how can you move an application for discharge now?
That is your lordship, my lord's judgment.
Show me.
Yes, your lordship. At page 3,
Page 3, yes.
my lord. Even if this case, the BNSS doesn't apply, this honorable court was of the view that this is the spirit of the law. Page paragraph 10. Eventually, the new provision cannot come into play in case at hand, but keeping in view the legislative wisdom of the providing an opportunity by the new enactment, this court is presumed to hold that in peculiar facts of the case, where the entire exercise was completed on the same day, as evident from the impugned order, interest of justice should be subserved if an opportunity is provided to the petitioner who seeks discharge. Accordingly, the impugned order is set aside, giving liberty to the petitioners to move learned court in session within a week hence, along with the copy of this order seeking discharge. If such an application is filed, the same shall be considered and disposed of within 10 days. Thereafter, it is needless to say that the petitioner shall cooperate and shall not seek any further adjournment. In the event no such application is filed within the time stipulated, this order shall not be acted upon.
Has it been done in the same day?
Your lordship.
Same day, your lordship, page 47.
Let us see. Yes.
Copies of the police paper are ready and supplied.
15/11/2023.
Where are you reading?
Page 47, madam.
47.
7.
Okay.
Copies of the police paper are ready and supplied to the accused person. Heard upon learning the FPP and learning defense counsel the same day, lordship. I have also taken the instruction. Until that, evidence has not been recorded. Trial not started.
Copies of the police paper supplied. Or the person so point of charge. Yes.
Yes,
What
lord.
do you say?
My learned senior is saying that the judgment in this case,
Huh.
the charge has been framed on 37/2024 after the new act.
No. 4/12/2020. That is sentence. 4/12.
There was framing charge against the petitioner shall also implement charge by the police.
4/12/2020.
Where is that?
Purna. Yes, it is Purna case. I was there in the court on that day. It is 2018 no case.
I'll set aside and give an opportunity.
My lord.
It has to be set aside. Right. Petition is agreed by the order dated 15/11/2023, whereby the court below, while supplying the court below had framed charges against the petitioner for alleged offences punishable under section 419/420/434 IPC read with section 66 bracket capital D IT Act. Mr. Mishra and counsel for the petitioner, taking me to the impugned order, submits that on 15/11/2023, the police papers were supplied to the accused vessels. On the same day, the trial court went ahead with the hearing on the question of charge, and framed the charge. He submits that since the police paper were supplied to the petitioner on the same day, the accused persons were entitled to look into the paper and prepare themselves for the purpose of addressing the court on the question of charge. Mr. Mishra is further relied upon the judgment of the order of the this court passed on 18/11/2024 in CRL REV number 644 of 2024. 24 to buttress his argument. He has relied upon para 6, 7, 8, 6 to 8, 9, 6 to 10, 6 to 10 of the state. Relying upon the aforesaid order for the coordinate bench, he submits that the procedural law, the new procedural law, which has replaced the earlier one, has contemplated about 60 days time to move application for seeking discharge after the police papers are supplied to him. He submits that since the trial court had proceeded to frame charges on the same day when the police paper was supplied to the accused person, the impugn order deserves to be set aside, and a fresh opportunity is liable to be afforded to the petitioner in view of the order passed by the in view of the new procedural law and the judgment and the order in Naresh Chandra Chopra. Taking into consideration the aforementioned, Mr. Mohanty vehemently opposed the same on the ground that charges has already been framed. The clock cannot be set back by affording an opportunity to the petitioner to move application for discharge after the charge having been framed. Taking into consideration the submission made by both the parties, I am inclined to set aside the order dated 15/11/2023 and direct the trial court to afford opportunity to the petitioner to be heard before the charges are framed. Accordingly, the so set aside, matter is remanded back to the trial court. Here the question of charge once again by affording sufficient opportunity to the petitioner accused. Yes.
One more submission also, though the charge is framed last 1 year. 5/11/23 is the day order frame charge. Now, my
And the same-
no witness in exam.
And
That's observation.
when the charge sheet was filed?
16/10/2023. That is page 43.
Since charge sheet in the present case has already been submitted on 16/10/2023, and all the police paper has already been supplied to the petitioner way back on 15/11/2023. Needless to say that the trial court should do well to see that the charges are framed as expeditiously as possible by affording opportunity to the petitioner within a period of 1 month. Hence, yes.
6.
My lord, item 6 and 7, your lordship, both the matters. Your lordship may kindly say item 6, the accused, and item 7, the wife of the accused, both entangled in a vigilance case.
Yeah.
I have prayed for quashing, your lordship,
Yes.
on the ground that I am not supplying any document here in your lordship, not a single document from defense. Your lordship may kindly see
In the item 6, you are the husband,
husband,
and 7
7
is the wife.
added as an accused abettor. She is
Yes.
not employed. She is added as an abettor.
Yes.
Yes, I an application challenging for passing of proceeding. That should be withdrawn first.
That I have already withdrawn. No, withdraw. Hey,
What are you seeking in this petition?
that is passing of the cognizance, your lordship. That my learned senior, what he is saying. No, ମୁଁ ଟିକେ କହୁଛି ଆଜ୍ଞା, ମୁଁ କହୁଛି. Your lordship, may kindly see page 2 of my.
No. Have you filed any other petition?
Yes, your lordship.
What is that?
That is CRLMC 1560 by 2020. ठीक है, ଗୋଟେ second କହିଦଉଛି. ମୁଁ ଲେଖିଛି ଆଜ୍ଞା, ମୁଁ ସେଟା.
Let me understand first what are you?
Yes, your lordship. Page 2.
There are two petitions. One is for husband, another is for wife.
This is present.
Apart from that, you have already filed two
Prior, your lordship, I have filed a CRLMC for Quashing.
which is pending.
That pending, I have filed a memo mentioning before your lordship that it is to be withdrawn.
Okay, let us understand the cognizance order. What is wrong in it?
Yes, your lordship.
Yes.
My lord, your lordship may kindly see, herein your lordship, I am not submitting a single new document. The document which has been submitted, that is, I made a prayer in the mentioning that from paragraph 8 to 20, let them say, only your lordship, re-addition. Whatever they have submitted in the charge sheet, if it is, first they have filed a case that I have got 128% beyond the known source of income.
Yes.
Investigated, I produced all the documents, now they reduced to 30%. Straight away from 120 to 30%.
Yes.
The reason, your lordship, it will come to 10%, case cannot be made out against me as per the San Swami case. So they reduced it to anyhow 30%.
20% ahead of the threshold.
20%, yes. So somehow managed to record 30%. Whether it can be 30%.
That somehow is only the test.
Somehow is only the test.
That
Your lordship may kindly
somehow
see,
part has to be tested.
my lord,
Trial.
if it is simply added, whatever they have submitted, then it will fall below 0%, even it will come to minus.
Show me one
Yes,
example.
only one I am submitting. I will
Yes.
not take much time, your
Yes.
lordship. Page 90, 90.
1990.
That is part of the charge sheet.
Okay.
Even I am astonished, my lord, that this is possible. Page 90, my lord. Serial number 28.
Yes.
My lord, I have availed loan of 6,01,000.
28.
Then 28. I have availed loan of 6,01,000. Then your lordship 3,50,000. The addition will come to 9 lakh, my lord. Your lordship may kindly see. And this is,
9,51,000.
yes, your lordship. And it is ever, forever. My lord may kindly see page 162. I am straight away coming to the point. In final charge sheet 162, serial number 28. 162 page number. Final charge sheet, same thing.
$162.
Yes, your lordship.
Yes. Yes.
The same thing. 9,01,000 added with 3,50,000 is 9,01,000.
Oh, that is 50,000 rupees.
Other, your lordship.
ସେ ଯୋଉ 50,000 କହୁଛନ୍ତି ଏଇଠି ଟାଇପରେ ଫାଇଲଟା ଛାଡି ଦେଇଛି କିନ୍ତୁ ଟୋଟାଲିଂ ଅଫ ଆସେଟ ରେ ସେ ଏମାନଙ୍କୁ ମିଶିଛି
No, my lord. No.
that is the
No, my lord. I strongly submit it is not.
Oh, that 50,000 is neither here nor there.
Yes, thereafter.
Will it come down to less than 10%? If 50,000
Thereafter, your lordship. Thereafter, your lordship.
In any case, I at the cognizance stage, I can't keep on calculating this.
Only, my lord, addition.
So therefore, you move application before trial court for discharge.
No, my lord.
Let that exercise be done by the trial court. In the 482 proceeding, how can I start calculating?
My lord, 9,01,000 or 50,000, this is only addition.
This is only 50,000.
Thereafter, your lordship. Yes, your lordship. I am submitting. My lord.
Say that in the totaling, everything is taken care of.
Yes. No,
Maybe a
my lord.
typo.
No, so I strongly submit no. Your lordship may kindly see page 84. Again, ମୁଁ ବି verify କରିଛି. Page 84. Page 84, my lord.
Yes.
ସେଟା ମୁଁ verify କରି କହୁଛି. ମୁଁ ସେମିତି
ତାପରେ ବି ଚାର୍ଜ ସିଟ୍ ରେ ସେମାନେ ଗୋଟେ ଆଡିଶନାଲ ଦେଇ ଦେଇଛନ୍ତି କୋର୍ଟ କୁ ଯେ ସେଟା ଭୁଲ ହେଇଥିଲା that should be treated
ହଁ ସେଇଟା କୋଉଠି ଦେଇଛନ୍ତି ଟିକେ ଦେଖାନ୍ତୁ.
ଦେଖି ଦେଖି କଣ ଅଛି ମୋ ପାଖରେ
ହଁ ତ page 84, your lordship. Page 84, they have shown a plot in CDA. Page 84, serial number 1. My lord, may I place it, your lordship?
page
84.
Which one?
CDA, one CDA plot is
Yes.
1,42,000 is the plot cost.
Yes.
Then page 85, your lordship, serial number 3. The cost of the building is 13,74,000. my lord. So it is added, your lordship. This is my asset. This is my asset, my lord.
In the same plot.
The building our land, এটা ঠিক আছে আজ্ঞা. Building land, this is my asset. Yes, your lordship. Your lordship may kindly see page 93.
Yes.
Page 93, serial number 52. I sold that plot and got 40 lakhs. Same plot I sold and got 40 lakhs.
52.
52. Same plot I sold, land and building, and I got 40 lakhs. Now, if I got 40 lakhs, this is my income. That land building cannot be my income. If land building is mine, then 40 lakhs is not mine.
That is to be adjusted.
Yes, your lordship. My lord, not let him say.
And on the date of search, until date, it has not yet been transferred from the name of the petition.
My lord, they have stated. No, it is sold, my lord.
All these things can be, this exercise can be done by the trial court only. You move application before trial court, specific 227 application. I'll give a direction to pass a reason order.
My prayer is that, your lordship, I have simply provided this calculation on paragraph 8 to 20. Let my learned senior at least go
Why
through
should
one.
I undertake that exercise at
My
all?
lord, this is what they have shown. It is not I am
That's
shown.
right, but you go and impress upon the trial court. See, these calculations are not done or done whatever. In a 482 proceeding, if I start calculating this, then there is no end to it.
I am not, my lord, submitting any difficult calculation. I am only submitting.
It's
that
easy
is-
for you. I'm very poor in mathematics. That's another issue.
My lord, your lordship may kindly consider one point.
Do
My
I
lord,
need to go into all these things?
my lord,
482.
one point, my lord.
You move specific application, I'll indicate that the trial court has to deal with it.
No, your lordship may
That was the
direct.
part.
Your lordship may direct. Let the trial court consider why I am submitting, your lordship.
That's what I'm saying. Trial court has to consider. That's
This,
what-
let him consider this cognizance again, your lordship.
No. I'll not set the clock back.
Why I am submitting, my lord?
No.
The reason is, your lordship.
There are procedure for that.
Procedure in the
And in the charge
Though-
stage, you can very well tell the calculations are wrong.
though in the old provision, old CRPC, there was no provision of considering recognizance at the instance of accused,
Right.
but it has been introduced in the new law.
That's right.
I really submit this is not applicable to my case because it is before 1/7/2020.
Yes.
But your lordship may consider if at this stage, your lordship, whether I am required to enter appearance and say
That's a different story. Right?
if the land and
Mr. Mishra
building,
and the petitioners have.
then your lordship may kindly permit that all these specific points.
You take specific point. That's what I'm recording. I will just record that you have pointed out many calculation problems. Those problems will be attended by the trial court.
But the difficulty is that they have fixed the date, your lordship, I have to appear, go on bail, and then everything.
These are the procedure what to do.
On these materials, if your lordship, I am dragged to charge, your lordship may kindly say prima facie in a case is not made out. The same land building, they will say that it is my property, same land building sold, and the income will be shown mine.
If you want me to dispose upon merit, I'll do it.
That your lordship may,
I'll reserve the judgment, I'll do it. And that then the observation may create problem for you. At this stage, why are you inviting?
My only submission, your lordship, that these points should have been
Okay,
taken
it's
into
all right.
consideration.
Let us stop it now. Right now, petitioner.
So my lord may permit me to take all these specific pleas.
That's right. I'm saying. Petitioner is agreed by the order dated 3/5/2024, passed by the special judge vigilance Baleshwar in Baleshwar vigilance PS case number 15 of 2020, whereby cognizance of offences punishable under section. What is that annexure?
Annexure, my lord, that is
Impugn order.
Annexure 4, page 179.
Yes. Offences punishable under section so taken against the petitioner. Mr. Mishra and counsel for the petitioner has extensively argued on the calculation part and pointed out that there are apparent errors in the mathematical calculation made by the vigilance department to establish that the disproportionate asset is beyond 30%. 30%. If the calculations are redone, then the disproportionate asset will come much below 10%, much below 10%, much below 10%. Therefore, prima facie there is no case made out against the petitioner. He has pointedly indicated 2-3 entries from the charge sheet to establish his case. Since the petitioner has assailed the imbue order, where cognizance has been taken, I am not inclined to entertain this petition at this stage. However, liberty is granted to the petitioner to move appropriate application, seeking discharge from the case by on all the grounds, including the grounds raised in the present petition. If such application is moved, the same shall be considered by the trial court by dealing with individually dealing with the entries made in the charge sheet by the with the regional. Individually, each entry has to be looked in. Both the matters like that. Yes, dispose of. Yes.
8.
My lord, may I pray some urgent certified copy because 4th
Yes.
is the.
Actually, compromise matter but parties are present. My friend is for the complainant, my lord. I rising out of a complaint case, my lord.
What are the offences, sir?
My lord, offences 436, 323, 336,
Okay.
147, 148.
Okay. Who is the complainant?
Complainant, she is the complainant.
How
He is the
many? How many accused? 8 accused.
8 accused, my lord.
Okay. All of them are there.
My lord.
Right. At the instance of opposite party number 2, the complaint case number ICC case number 43 of 2005 has been initiated against the petitioners. What is the stage?
Stage below trial has not begun.
When the trial is about to commence, the parties have settled the dispute and the petitioners have filed the present petition seeking quashing of the entire proceeding arising out of 1 CC case number 43 of 2005. The petitioners and opposite party number 2 are present in the court, being represented by their respective counsel and identified by them, and they have also filed their self-attested copies of the Aadhaar card to establish their identity. They have filed the affidavit.
Yes, my lord. Joint affidavit has been filed.
The petitioner and the opposite party number 2 have also filed joint affidavit dated 4/11. 14/11. Huh? Where is that? 14/11/2024. Inter alia stating as under. Inter alia stating nothing.
We have stated.
Inter alia stating nothing. What is this? What is this affidavit? Inter alia stating anyway. Complaint. It's a complaint case. Why should I? Inter alia stating as under 1, 2, 3. 1, 2, 3, and 4. 1, 2, 4. 1, 2, 3, and 4. Where is the opposite party?
My lord, we are seeking quashing on 2 legal grounds. My lord, number 1 is the complainant is the investigating officer, which is not permitted as per the law laid down by my lords.
Show me that.
My lord,
Which
just
part?
turn to the FIR. That is at page 19.
29?
19, my lord.
19. Okay.
19.
Yes.
FIR starts from page 19. But the please turn the page, my lord, at page 20. The name of the complainant.
20.
Sri S.K. Das Mahapatra.
Yes. S.K. Das Mahapatra. Inspector.
Vigilance Cell Cutter.
Yes.
Then, my lord, turn to page 25.
25.
The endorsement of the superintendent of police in the handwritten note received the report today, that is on 22nd September 29.
Reveals a cognizance of and so on so
And my lord, this is says Mr. Das Mahapatra, Inspector of Vigilance Cell is
S.K. Das Mahapatra, Inspector of Vigilance Cell, Cuttack is
entrusted to take up the investigation. And he is the investigating officer who filed the charge.
Yes, sir.
My lord, I am relying on Mohanlal.
That has been set aside and overruled in Constitution bench in Mukesh Singh 2010.
Show me that.
2020 volume 10
I'll pass over, get it.
Constitution law.
Pass over. Then I'll issue notice, let us.
Another aspect is the petitioner before this honorable court thrice. And one in CRMC 1661/2212 that was disposed of with a submission.
What was
My lord, then second submission is because then simultaneously investigation was, the departmental investigation was going on. Now investigation they have dropped after the recording on merits. The directorate passed an order. My lord, that is at page 48.
40 years.
My lord, it is page
9 years.
They have challenged the proceeding. Liberty was granted to raise all the points having of charge. Discharge was rejected. They approved this honorable court. This honorable court was not inclined to withdraw the petition with liberty to raise all the points during the course of trial. This honorable court trial, and now trial is going on. 13 witnesses has been examined. By them.
At this stage, what will you do?
No, my lord, at this stage also, now these documents, my lord, the trial judge cannot look into this because when the charge was framed, this was not there.
Then
Now, after the proceeding, the order, this is the final order. And now, Supreme Court, as per the law laid down by Supreme Court, because if on the same set of facts, if I am acquitted or discharged by the department, you cannot initiate criminal proceeding against.
So that judgment, you are Kejriwal.
No, my lord, I am.
Which judgment you are?
I am in that Ansu Tiwari, my lord, Justice Nariman's judgment.
Just show me. Is it departmental proceeding or
Yes, my lord.
adjudication proceeding? Adjudication.
Let us examine that, my lord.
Yes.
referring to Kejriwal.
All are adjudication. All are adjudication.
But my lord, the ratio is the last word, one line, my lord.
Yes. Which paragraph you are relying upon?
Para 7.
Yes. Yes. 7.
Then my lord, a number of judgments have held that the standard of proof in departmental proceedings being based on preponderance of probability is somewhat lower than the standard of proof in a criminal proceeding where the case has to be proved beyond reasonable doubt. In PS Raja, they have discussed all these things, my lord. Then, my lord, just turn 2 pages. Then, after referring to the various judgments, this court then called out of the ratio of those decisions in paragraph 38 as follows.
Yes.
The ratio which can be called out from this decision can broadly be stated as follows. Adjudication proceedings and criminal prosecution can be launched simultaneously. Decision in adjudication proceeding is not necessary before initiation of criminal prosecution. Adjudication proceedings and criminal proceedings are independent in nature to each other. The finding against the person facing prosecution in the adjudication proceeding is not binding on the proceeding for criminal prosecution. Adjudication proceeding by the enforcement directorate is not prosecution by a competent authority of law to attract the provisions.
That's what I'm saying. These are adjudication. Departmental proceeding cannot be equated with the adjudication proceeding.
No, my lord, then in PS Raja, that was this is based on PS Raja.
Anyway, I'll issue notice on 9th. I'm examining. A group of matter I'm examining on this issue. I'll issue notice on 9th. 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 The other matters are pending. 9th. Issue notice 9th. And there is no urgency now. Trial is going on. You move an application. Move an application for adjournment. Because the same order is passed there in those matters. Move this petitioner may move an application before the trial court seeking an adjournment owing to the fact that the matter is sub judice before this court. Yes. 9th. Yes.
I can tell.
But the Mr. Patra, you have to research on that.
My lord,
see, there is a vital difference between
what is falling from my lord. I understood.
So there are batch of matter on 9th. Because there is one. Where is that? Fourth. Here you are there. Fourth. See, what is that judgment? Mr. Dharo was arguing. Meenakatan Pani. He is relying upon Meenakatan Pani. And that judgment has already been diluted. A singular judgment of this court.
My lord,
that is diluted.
My lord, in this case, I will show from record itself
Oh, that is on merit again.
That is because what happened, the allegations in the departmental proceeding and the FIR and charge sheet is same. And after going through all these things, the recorded was, I was not posted at that point of time. I transferred in 2007. Allegation is of 2009. And the departmental.
Now,
I will allow you to examine that witness as a defense witness.
My lord, no, my lord, I will try my luck here. My lord, it is very difficult to go.
I'll give a direction that you will be allowed to examine that witness, that the officer who has exonerated you as a defense evidence. Defense witness. We'll see. Fourth.
My lord.
Yes.
May I please, my lord? The Quashing of FIR on the section 363, 366, 366A and 34 on the ground of compromise, my lord.
Yes.
I filed the compromise petition and my learned friend is appearing on the behalf of
What
the
are the
complaint.
offences, madam?
363, 366, 366A and 34 of IPC.
What is the age of the victim?
19.
Huh?
19.
But the
What are these?
time of offense is 40.
But both are married to accused.
They are married.
Married.
They are
Both.
married and blessed with child.
Right.
I'm
Where are they?
They have today. They have not appeared. They will come from Subarnapur. Short date may be fixed. They both the
Why? They can come today also.
Subarnapur, my lord.
When? Tuesday? Wednesday? When do you want?
And Wednesday.
Wednesday. Huh? Settlement matter. Huh? Bring them. If they can't come, through VC. Okay. And get an affidavit also.
Yes, ma'am.
Joint affidavit?
Yes.
Okay, yes.
May I please?
Yes.
The impugnator is in the next formula. My 205 application was rejected and NBW has been issued. Petitioner is in Inspector Millard is posted at Madhulpura Police Station.
NBW, I'll cancel it. I'll cancel them. NBW. You are on bail. Date?
During, well, that order itself says, I was arrested on 14 to 2014 and released on 19 to 2014.
Petitioner was on bail. Why the order dated?
14 to 2014 Millard, I arrested Millard and released on 19 to 2014 Millard. You'll also kindly see page 22 Millard. In the order itself, Millard.
Which court has given bail?
Trial court has it.
Trial court. Huh? Trial court. Granted bail trial court. 12/11/2024 is the NBW. Huh? Okay. Cancel. 500. Yeah. Item 12.
May I please, your lordship?
Yes, sir.
I am appearing for an appearance. Engagement will appear. Millard, here's an instant case, Millard. The case FIR was lodged on 25th of February 2006. And Millard, the charge sheet was filed 2009 and the cognizance was taken 2010. Millard, I am raising a legal point before lordship.
Yes.
Where the petitioner is the license holder from Jabalpur for deal with explosive, and his driver and Millard caretaker was carrying the explosive in a wooden van, specially modernized van from Jabalpur to Millard doing blasting in the Bhushan Steel. The Bhushan Steel company was Millard expansion. A anonymous call was received by the police. Police Millard went to the Bhushan Steel campus and found that the van was carrying some denominator and some explosive materials. It is the case, admitted case, that it is the license holder, nothing ambiguity. I am not going to merit, just I am giving the picture. And the denominator which is supposed to carry in a separate van, but the petitioner and his driver and they have violated, they have carried the same articles in a particular van. This is the allegation. I have raised one simple point. The Millard trial court Millard took cognizance on 2010, which is the beyond limitation. My legal point is 468 CRPC as lordships are dealt. So 468 is a bar for taking cognizance, and the Millard the proceeding is vitiates. If instead of Millard taking all the grounds about the vicarious liability other part, I am only Millard praying your lordship. Annexure Millard 9 is the order passed by the London JMHC, page 54, where he didn't allow me to go and discharge. So discharge for discharge. So I pray the matter may be remanded back for to take fresh look of the legal ground which I urged before lordship 468 CRPC, where admittedly occurrence of 2006, annexure 5, 20.
What are the offences?
Offences, my lord, yes. Offences is for
286.
286, it is fine for carrying you to 286.
286.
6 months or fine. That also explore about the things.
And read within 9 capital B, small b.
And 286 টা দেখুন।
286, no?
Yes, 286. 286 fixed, my lord. Yes. 286 fixed, my lord. I'm reading. Negligent conduct with respect to explosive substances. Whoever does with any explosive substances any act so rashly or negligently as to endanger human life or to likely to cause or hurt injury to a person or knowingly negligent omits to take such order with any explosive substance on his position.
286 and next.
It is
Next.
6 months or fine.
And next.
9B of punishment.
B, section 9, capital B.
It is
small b,
explosive.
explosive.
What is the sentence?
Yes, I am saying.
What is the sentence?
Only, my lord, 2 year or fine.
Yes.
And admittedly, my lord, after 3 years, 11 months, the conscience taken. So I may urge to, I'll lordship remind back the matter to the GMFC to a press look, the point to be adjudicated, and he will pass an order. Because I am backed by Supreme Court judgment that that is, my lord, State of Punjab versus Sarwan Singh. My lord, State of Punjab went to appeal to Honorable Supreme Court. Supreme Court, my lord, declined to interfere about the, because the trial will vitiates.
Yes. Exclusive.
Yes, I'm 9B, my lords. 9B.
9B.
B of small b, capital B and small b. That is small b, lordship, kindly see. Page 12 of that. Punishment, purchase, uses, sale or transport. I am not admittedly transporting my driver and caretaker, though I admit the license holder, my lord, that is 2 years or with fine. If my lord not succeed, I'll go by other class. If the Lord, my state may take a fresh look of this, because admittedly cognizance taken 2010. Page 53, annexure 8 is cognizance, my lord. Kindly see. Running page 53, annexure 8. Hmm? 53, 57. 53. Yes.
This is a special statute.
My lord.
468, how will you apply this? Is there any bar?
Yes, my lord, that is also there. It a 9 page.
Which is the relevant provision? Yes, Mr. Vishal, what do you say?
Also, Punjab and Haryana High Court also dealt with 9B. Yes.
Exclusive.
Yes.
Because these are special set. We can't.
Yes. So also minor kind.
Where is that? Which paragraph?
They have also dealt about that for page 7. It is also in similar special test statute Honorable Punjab and Haryana, page 7, 468. On Procedural Opposite section 468, they have also dealt. Last page again. Front page, your lordship, page para 4, it is 9B, 9C.
Yes. Offense, show me the offense.
Offense, my lord, kindly see.
Yes.
Your lordship, you can see page 53, where the magistrate took cognizance.
Yes.
Or, my lord, page, annexure 8, page 53, your lordship.
Yes, I'm there.
Yes. Admittedly, my lord, the occurrence in the year 2006.
Where
And
is
this is
that?
10. 12/1/2010.
Hmm?
Your lords, the order dated 12/1/2010.
12
12th January.
12 January, yes.
Page 53, annexure 8, my lord.
Yes. Handwritten one.
My lord, yes.
Handwritten.
Handwritten, yes. The offenses are, my lord, written under section 286. But from the top, 286, 34, and 9B.
Yes.
And, my lord, the cognizance was taken after beyond the limitation period.
12/1/2010.
And the occurrence.
Show me the incident. Show me
Incident
the-
kind annexure 5, my lord. Page
5, annexure
5, page
5.
23.
Annexure 5. Okay. Incident, date of incident.
The first page, you also may see, kindly see, that is dated
Information.
25th of February 2006.
Yes.
Yes.
Directly covered. Well,
468.
Citizen,
Status.
you raised all these points.
Your lordship may that also observe the two judgments so that it will be handled.
You are.
I'm the owner.
You are challenging what?
I'm challenging the discharge order under annexure
Impugned order.
9, annexure 9, impugned order annexure 9.
Petitioner is agreed by the order dated 5/3/2024.
Well,
Passed by the learned
JMFC Bonpal.
So, whereby his application under section 239 CRPC seeking discharge has been rejected on merits. On merits. Mr. Lalit Misra, that a counsel for the petitioner, submits that the trial court has taken cognizance for the offences, and they submits that the admittedly the incident pertaining to which the FIR has been registered has had happened on
25 February 2006.
25 February 2006. And the Learned Trial Court has taken cognizance of offence by the order dated 12/1/2010. 12/1/2010. Much beyond the prescribed limitation under section 468 CRPC. He emphasized on the provisions of 468 CRPC and submits that both the offences for which the cognizance has been taken, namely the offences punishable under section 286 IPC, as well as the offence punishable under section 9B
and small b
of the Explosive Act 1884 attracts maximum sentence of 6 months. Maximum sentence of 6 months. Therefore, under the
2 years and 6 months. 2 years in below the explosive and 6 months.
2 years. 2 years. 2 years. Maximum 2 years. 3 years if the offence is punishable with imprisonment for therefore, he submits that under the subsection C of section 468(2), the limitation for taking cognizance is 3 years. The 468, he read out the provisions for 468. 468 since the maximum sentence prescribed for the alleged offence punishable under section 9B of exclusive act for which the petitioner is sought to be tried attracts a sentence of 2 years. 2 years. Therefore, therefore cognizance ought to have been taken for the said offence within 3 years as contemplated under section 468 CRPC. 468 CRPC. Mr. Lalit Mishra further relied upon the judgment of the Punjab and Haryana High Court, Manupatra and Manupatra print, so and so, and he emphasized on para para 2 and 2, 4 and 6. 2, 4 and 6, which reads as under. Relying upon the aforesaid judgment, and the provisions of law, Mr. Mishra contends that the impugn order contains that the trial court has not taken into consideration this aspect of the matter. Hence, the impugn order is liable to be set aside. I am in complete agreement with Mr. submission made by Mr. Mishra. Hence, I set aside the impugn order dated 5/3/2024, passed by Learned JMFC Bonapal in CT case number 358 of 2006, and grant liberty to the petitioner to move specific application for under 239 CRPC. 239 CRPC. If such application is moved, 239, the petitioner is also granted liberty to raise all these points as has been taken in the present petition before the court below. If such application is moved, same shall be considered on its own merit. Yes.
Grateful.
460 video exclusive to be and exclusive interview 2B exclusive and 286 IPC. Yes.
13.
13, my lord. Yes.
Yes, appeal. Admitted, huh?
1 year.
Press appeal 1 year. Admitted. Criminal appeal. Suspension of bail granted. The realization of fine is state and the TRC cost. Yes.
1 year.
1.
1.
Yes.
Recopy.
Yes.
Obvious.
Yes.
15.
May be lordship. It's a Belgium matter. The petitioner was released on bail 4/10/2012. Issue NBW 6/2/2017.
Okay. No, 1,000 crore. Which Baleswar district court? District Baleswar. 1,000. Yes.
Obvious.
Yes.
16.
Yes, sir.
Belgium matter, my lord.
Yes.
Petitioner was released on bail on 27/8/2018, my lord.
Yes.
And NBW was issued on 17/5/2022.
Okay. Nagar. Huh? Nagar. 19, huh? 18. 1,000.
Well,
Nagar. District bar.
17.
May I please, the lordship, the Belgium matter, my lords. The petitioner was on bail granted by this honorable court by order dated 7th October 2016. Thereafter, my lords, NBW was issued on 21 January 2017.
17.
Lordship.
How many of you are there?
Lordship, one petition.
1,000. Ungold.
Lordship, CTM ungold.
Ungold Barasi. Ungold Barasi 1,000. Yes.
18.
18, your lordship, this is the same appeal for restoration of a second appeal, your lordship.
Any delay?
Yes, your lordship, there's a delay and there's an IA for delay.
How much delay?
It's a 1 year delay, your lordship.
Huh?
Almost 1 year delay, Your Lordship.
Do you have good case on merit insofar as that CRLMC is concerned? CRLMC?
Your Lordship, it's about the second appeal, Your Lordship.
Hmm?
Second appeal.
Second appeal.
Second appeal.
The rest of second. Rest of second appeal. Pay 1,000 to the bar. Really condone, subject to cost of rupees 1,000 to be paid to the High Court Bar Association. Give it to Bar Association. Second appeal.
Cost, Your Lordship.
500.
Your Lordship, the delay was not deliberate, as in the erstwhile counsel was
500, give it to Bar. What is it? You give. If your senior would have come, I would impose more cost.
90.
Give it to High Court Bar.
Yes. 19, the last time, Lordship, I had submitted that the present accused is suffering from blood cancer. Lordship had agreed that this matter will be heard in orders. The learned counsel for the vigilance too had agreed. Aji reference ଅଛି ଆଜି ନହେଲେ ବି ଆଉ ଗୋଟେ ଡେଟ୍ ରଖିଦିଅନ୍ତୁ ଆଉ ଗୋଟେ ଡେଟ୍ କରିଦେବା.
I'll adjust the date.
Lordship.
Trap case.
Trap case is not much time.
It's blood cancer before she.
15 minutes.
I agree. I do.
Your Lordship may fix the date.
आगे.
Wait, we'll see.
I have made the notes and I will prepare the written note of argument.
हाँ move it.
आगे.
Last week of December.
Date देखिए.
Last week of December may be fixed.
Last week of December, January first week. देखिए दिया. Yes.
20.
You would have go to January. I just keep it.
Item number 20. Mr. Pandit's like another
Password.
Password launch for it.
I don't know. Password may come immediately after some time.
शनिवार दिन सर we have other assignments sir हेला जाओ आरो शनिवार को जाओ.
Mediation fail. Is there anything on merits?
Merit that cognizance matter, your lordship must have remember my learned senior Mr. Palit was arguing that inspector matter.
Yes.
That inspector matter, where I am appearing for the informant. Your lordship has had the matter at length for many times, my lord. And today your lordship has kept it since because it's a Saturday and your lordship can give much more time. Because at least, my lord, half an hour to 1 hour.
Is there anything on merits?
My lordship, last occasion your lordship has asked for 161 statement. We have already filed it. 161 statement. 161 statement is also there, and it is in a silk cover.
Petitioner has prayed for quashing of cognizance, my lord. It's a 376 and 3 SCST matter, my lord. And my learned senior is
on merits you have nothing.
No, my lord. Visakha ground, my lord.
That is
that senior will argue, my lord.
Okay, adjourn.
Yes. Shorted.
We'll give. We'll adjust and give.
Merit out of Saturday Saturday your lordship has kept specifically your lord only because my lord in the
Saturday will it suit you?
Out of Saturday
7th.
7.
On that day.
Sorry,
I'll adjust. Wait, we'll give the
December 5th.
Wait, we'll give the date. We will consider and give it. Okay. Adjust. Yes.
21.
Please, your lordship. Paying for an adjournment.
Why, sir?
Sir, due to on behalf of the Sukanta Kumana, he's ill today.
What is this matter is about? Let us see.
For the
DV
case.
Yeah. And it should have first approved before the ordinance court below. That yes, there is first that is appealable also under section 29 of that. And the same challenging the same proceeding. The which Hazarika has approached the Hon'Ble court. CRM note 2470 of 2024. And the same proceeding.
Yes.
And this Hon'Ble court has directed to raise the same point before the court.
Show me. I'll pass the same order.
This is the mouse.
Lordship, last chance going to be handled, Lordship.
He should approve before the law decision, right?
Lordship, last chance to be given.
She's
Mouse.
Lordship, last chance to be given.
You don't leave anyone. Anybody
Last
mediator.
Arrange the marriage.
She has rather helped you for your marriage.
Yes.
If the marriage has gone wrong, what will she do?
She has demanded along with others.
to bring more money.
Lordship, last chance to be given. Lordship,
She has only helped you. She has only helped you to arrange a marriage proposal for you. And now for that you are.
Lordship, last occasion opposite party also taken. Lordship, last chance to be given.
Interim order to continue lease it.
Interim order. Obliged, Lordship.
22. May please, Lord. Right, minutes committed to your lordship. This is the judgment which covers. Magistrate has referred the matter under 156(3) for a police report. The entire inception is bad because of this judgment, my lord. It has already been decided. 2009 7 SCC page 526. My lord, this is the case where, my lord, we have been, the CEO directly has been made a party for violation, my lord, of a provision under Water Act and Forest Act. Now, Water Act, I'm just Air Act and Water Act. I'm just reading the, my lords. Exactly, my lord, same word by word, same provision regarding cognizance is there in the Water Act for which our complaint has been filed against us, and in the Air Act.
Let us see the complaint.
My lord?
Let us see the complaint.
Complaint?
You are challenging what? Cognizance.
The entire initiation would not have been.
Yes.
My lord, 156(3) procedure is foreign. The order of the magistrate is this. Page 11.
Page 11, huh?
Page 11. Short order. I take 1 minute to place the order. The order arises out of petition under 156(3). This itself is not, my lord, maintainable.
Page 11. No. Okay, page 11.
No, sorry. Next page 66. Sorry, page 66.
Oh, that's perfect. Page 66.
Page 66.
66. Okay.
Order dated 16/2/2024 by the magistrate.
65. Where is 66? No, there is some problem in your pagination.
No, 66 starts.
This is which matter you are? No,
I am in Malas 570.
Sunil Gupta.
Yes.
Sunil Gupta.
Yes.
66 is something else.
66.
66 starts from Annexure 4, madam.
Annexure 4.
Yes.
That's 66, madam. So complaint.
Complaint. Okay.
Complaint, sir.
Yes.
The order is on page number 71.
Order is on page number 71. That is the class.
Okay. 70?
71.
71.
71.
Okay.
The order arises out of the petition under section 156(3) CRPC.
Who is the complainant?
My private party.
Oh.
He has complained to X, Y, Z and everybody else and not to the board.
Someone is appearing on behalf of the complainant.
The simple knowledge on the face of it, the board
21-24 of Environmental Protection Act and the so and so Water Act. Huh?
Yes. Now, that the complainant has also mentioned that in the complaint petition that he has given written report to the IIC Badmal. Now, IIC Badmal is the non-entity in the proceedings. It has to be
he
the
is
board.
given to the Superintendent of Police Jharsuguda, but
Yes.
no action was
They are all
taken.
not
Complaint petition reveals that forward. Let us see the judgment.
I'll just place that judgment, my lord. Even
Earlier also.
Let us see.
Judgment, my lord. Paragraph, page 36, para 18, last part. Cognizance of offenses. For a second only, because this is the exact same provision. Facsimile.
Yes.
No court shall take cognizance of an offense under this act, except on a complaint made by the appropriate authority concerned or any officer authorized in his behalf by the central government or by the state government, or as the case may be, the appropriate authority.
Yes. What are the violation of Water Act?
Water Act is, Water Act is, my lord, page, here at Water Act is. Water Act is 49 section.
49.
No court shall take cognizance of any offense under this act, except on a complaint made by a board or any officer authorized in this behalf by it.
Or by any person.
Yes.
Who is given notice.
Of not 60 days in the matter prescribed of the alleged offence and of his intention to make a complaint to the board or any officer authorized by the board. Now, board has been defined under this act.
Yes.
Board has been specifically defined here.
Board means the central board or the state board?
Yes. Board means central board and state board. Here, he says he has given it to the IIC Badmal,
Yes.
the SP Malat, and then the court, Supreme Court.
Yes.
Well,
What is the ratio now?
Now the ratio is at page 25.
25.
Paragraph 25.
Paragraph 25.
This Toho, your lordship, is now, but I appreciate that it's the same process. Section 22 of the Toho prohibits taking of cognizance.
Like 49, akin to 49 here.
Mala.
Yes.
Akin to 49, except on a complaint made by an appropriate authority or the person who has made the complaint earlier to it, as laid down therein, which means has to be the board or the authorized officer.
Yes.
The respondent, although has all the powers of an investigating agency, if expressly has been statutorily prohibited from, it has been expressly statutorily
Filing police
prohibited.
report.
Yes. Even though he is expressly prohibited from filing a police report.
Yes, madam.
My lordship.
He could file a complaint petition only as an appropriate authority. Further,
Directly covered.
Yes, my lordship.
as
I've seen
to
that, but
comply with the requirement, and the next sentence, Manas.
Yes.
If by reason of the provision of Toho, filing of a police report by necessary implication is necessarily forbidden. The question of submitting a report in terms of subsection.
Completely forbidden.
Yes, my lordship, I've
Completely
seen that, but last
It
occasion,
is
your
on the
lordship,
face of it, the entire procedure of inception is banned. Why?
may the complainant be appeared, my lordship, last
I
occasion.
is completely covered with judgment. Why should I wait for that?
It's completely
There is nothing in it.
without doing.
Nothing. Okay. I'll reject the judgment.
Grateful.
She's appearing for opinion.
You are appealing for opinion number 2? Yes. Do you want to say anything?
What can we do?
You are entitled to say, no problem. Directly covered what to do. Will you file? Okay. Party judgment result, parties are granted liberty to file a written note not exceeding 5 pages. Don't
Our prayer, all subsequent proceedings will be quashed also. Every proceeding.
consequential property.
All
Yes, consequence. Yes.
Great.
It's happened already. You within 2-3 days.
Yes.
You don't want to file it.
No, no, we have already filed.
You already filed.
Yes.
Exhaustive one, but this judgment.
In the past,
In his anxiety, my learned friend has exhaustive note. I don't blame him for that.
Para 25, na? Para
yes.
Well,
25.
25 is the.
Yes.
Grateful. Grateful.
23.
23 Milots, mediation proceedings are going on. The
Going on?
next date is posted to January 15th Milots.
After 15, January 15. Mediation,
First week of February Milots, the final report will also.
mediation is still going on. List it on February.
February first week Milots will fix it.
First.
Interim orders.
Entry not to continue.
I'm grateful.
Yes.
24. Item number 24, I prefer a short adjournment.
Why, sir? Adjournment. Thought
Against the order of cognizance.
Yes.
Audible, my
Yes, yes, I can hear.
My lord, may pass it over.
Yes. 1 minute. What did he say? Yes, Mr. Party, what do you want to say?
Lord, it is a order against the order of cognizance in the railway RPF matter. Against the proceeding against the accused, they have filed a
You are talking about item 25?
24.
24, huh? Okay, 24. Is he asking for adjournment?
Proceeding it sometime.
Okay, adjournment.
Any date may be fixed.
Date will be. Yes.
Or
Yes.
appearance may be not. Along with me, Mr. B. Chait is appearing.
Interim order is there?
No, my lord.
No.
No interim order.
Yes, okay.
Connection to
Lordship may reflect along with Mr. D. Gupta to the appearing.
Yes. Yes, name of both these. Yes. 25.
25, my lord. In this case, the husband and wife, they have got married. Your lordship directed for appearance.
Here, my lord.
I am for opposite party, my lord.
Yes, my lord.
What do you want in this position?
My lord, 2 weeks time to settle the, now settle is going on, my lord. He also want to file another CLMC that what I have filed a FIR against him, my lord.
What's a cross FIR?
Yes, my lord. He filed.
File it then.
Time, my lord.
Yes.
Time.
Both the offenses are not very serious.
Same 506 there.
ସେ sir ସେଇ FIR ଦେଲା ପରେ ସେ ଗାଡି ଯୋଉ ଗାଁରେ ଗଡୁଥିଲା ସେ ପୁରା ବନ୍ଦ ହେଇଛି.
Okay. Then I'll put it in the that week, 16th wala week. 18th, 19th, some 18th. 18th. By the time you file it, you get it tagged. 18th. Yes.
27.
This application has been filed by the husband and in-laws for quashing the criminal case.
Yes.
Actually, divorce has already been allowed and it was allowed through a compromise petition where it was awarded that both will cooperate each other for withdrawal and quashing of the.
Show me that.
Yes. That is Annex 1, series is the charge sheet. And the compromise petition is at Annex 2, page 29 to 32.
Yes.
And also OP2 is present. OP2 wife is present also.
Where OP2 is the complaint.
I am for OP2 wife. She is the informant. She is the informant.
Where are the accused persons?
Accused person, I have filed already a petition yesterday, day before yesterday. The petition number 1 is suffering and the old parent, they are also dependent, they are in Raulkela, they have not come. I have filed, that's why I have filed a petition for dispensing their personal appearance.
None of them are present. What to do?
No, unfortunately, they are not intentionally, they are in Raulkela, the parents.
But see, I don't know whether they are survived or what, whether they are in custody, what they are doing.
No,
I don't know.
They are not in service. Nobody is in there.
You should have moved an application. You should move an application seeking exemption.
I have filed.
Where is that?
They have already filed.
Dispensary of. Yes.
Already filed.
Where is that?
Number 317.
I-1 31?
76.
Okay. Show me. Madam. I will do something from my viewer. Yes.
Lordship.
Where is the opposite party number 2?
Opposite party.
The application under section under order 23 rule 3 PPC enumerating the terms of settlement. The annex 1 the terms of settlement reads as under para 3. Para 3. Persons next one. Persons there to the family judge Bhubaneswar allowed the civil proceedings number 134 of 2019 by dissolving the marriage between the petitioner and the party number 2. Next floor. In terms of the settlement agreement, the petitioners have now filed the present petition seeking passing up for the entire criminal prosecution initiated against them by the opposite party number 2. Opposite party number 2 has also filed an affidavit before this court on 28/11/2024 inter alia stating as under para 4 to 8. 4 to 8. Taking into consideration the opposite party number 2 will be appearing in person on query from the court has reiterated her stand and submits that she has satisfactorily received her alimony and settlement term has already been acted upon. Taking into consideration the aforementioned. White judgment window. Assembly Court white judgment window. Yes.
28 ordered separate copy.
Challenging the criminal proceeding and issuance of process manual. Offense under section 143, 186, 149, 283 of IPC manual. By the time of occurrence manual, the present petitioner was juvenile manual. Now he is in prosecuting his study and the maximum sentence is 7 months.
Yes.
6 months manual.
What are you
challenging the criminal proceeding manual?
Juvenile?
Yes, my lord. By the time of occurrence, he was juvenile.
He was 17 years, Lord.
17 years. Absolutely no allegation in the FIR against the petitioner, my lord. Since he is prosecuting his study, my lord, Lordship may take a lenient view, my lord. And in the charge sheet also,
what are the offences?
Offenses are 143, 186, 149, 283.
Okay, what are the allegations? Let us.
Allegation is that, my lord, FIR, page 12, my lord. Page 12,
12.
Annexure 1.
Yes. Yes.
Nice. Under the leadership of Sabyasachi Shakpati and Rajkishore Barik, assembled on the public road and thereby causing obstruction to vehicular traffic.
What is your name?
My name is Chandrasekhar Senapati.
Manas Kumar Marana,
Under the leadership of Sabyasachi Shakpati, my lord. They were making demonstration in front of the police station, my lord. That is the sole allegation.
Numbering about 9 in number, under the leadership of Sabyasachi Shakpati and Rajkishore Barik, assembled on the public and thereby causing obstruction to the vehicular traffic and holding placards and so investigation. After investigation, what are the allegations come against you?
The same allegation, my lord.
Against you?
The same, my lord. 143, 146, 149,
No, no.
283 charge sheet submitted.
Tell me the facts. Don't tell me the facts.
Same allegation as per the FIR, my lord.
Let us see. Your name has come.
Name is Cam, my lord.
Huh?
Name is Cam. Page 34. Same allegation as per the FIR.
In the FIR, your name was not there.
No, my lord. In the accused column is name is
FIR name
there.
is there, Lordship.
Accused column.
FIR name is there.
His name is there.
Yes.
In the accused column and in the last part, but no specific role played by the petitioner. He was just returning from tuition to his home, my lord. His name has been included. He was just watching.
Lordship. Yes, they're holding dharna like state
No, he has
demonstration.
not
He was
participated. He was just watching.
His career may be affected.
Yes, madam.
Placard, they took some placard and shouting Ahmedabad, Murdabad, and for that, why do you spoil their career? Think over it. Huh? I'm just issue notice and stay the proceeding.
No, my lord. On last occasion, notice has been issued, my lord, your lordship.
Stay.
Yes, my lord. Stay there.
Yes, 28.
Get some instruction.
I'll get.
Only for in respect of petitioner, my lord. Not I have challenged.
What petition for everybody is? What is that?
9 people are there.
9 people, but I came for only one petition.
That's right, but you are the one of the members of what is that? Surakya, Orissa Sena.
I'm not the member, my lord. That they made the allegation, that is the. But
what was your demand? Why you were
demanding, my lord? There was a irregularity in the local city hospital, my lord. For that reason, my lord, they are making demonstration. Against that, my lord, police people took away them. And
Against the ISC only they were doing. Yes.
But
what is this?
This petitioner has
some
no role to play.
local issue, these people were the agitators.
Yes, madam.
And taking some placards and all, they shouted.
2017 incident.
For that, you are prosecuting these young people.
I'll take instructions.
Yes, till that he has not received any summon also, my lord. Only charge sheet has been filed 2017.
You seek instruction. Let us close it. Unnecessary. Why unnecessary? Spoiling the career of
CD also.
Yes. Implement to continue.
Since next week, my lord, since it is the Durga Bazar police station quarter. Next week.
Only.
Next
Put it
week.
in. Yes.
29.
Lordship for CD also. Lordship.
Call for CD. You tell the police officer.
Yes, concerned
Take a
ISC.
lenient view and finish it up.
Lordship.
Yes.
My lord. My lord, item 29, Learned Vigilance Council, Mr. Sangram Das, she had informed early morning to our senior that he had some problem with his family, so he couldn't come.
Huh? Vigilance are same.
Huh?
30, my lord, I appear for the, he is not there. Interim was to continue. It was that case, my lord, where he himself was fair enough to agree that there is no specific allegation against the petitioner. One matter is there for reserve for judgment only. The other two are connected.
2018 and 22, I wanted to finish it up. Anyway, since he is not ready, I'll put it in some of the paper.
Well, Adam 29 interim order.
The other one is only reserved for judgment, my lord.
Which one?
584 of 2022, which is not there today. It's already there.
Anyway, if I'll pass some order.